Hi, my name is Attorney Stanley Helinski. I am a 25-year trial lawyer. I'm an appellate lawyer, corporate lawyer, litigated cases throughout the country. There are not many cases that I haven't handled. My 2 decades of practicing law, from class actions to divorces, really. I'm presently serving as corporate counsel for startups, but I'm still in the courtroom pretty much all the time, and in the appeals court plenty. Today we're talking about a topic that has come up over and over again in my practice. It's one that's near and dear to my heart. It's pets, or really any kind of domesticated animals. Pets are considered plain old property. That's right. Those loving best friends of ours are nothing more than a television or a sneaker when the court's concerned. Until today. The case that we're here talking about is Brett Lyman versus Sasha Lancer. It's Appeals Court 2023-P-73. The decision was issued on March 7 of 2024. Please stay for the cautions at the end of the video, or fast forward and hear the cautions at the end of the video. This case, even though it is really groundbreaking, make no mistake about it, it is very narrowly limited and will apply to certain types of cases. So you really want to check with a lawyer with every single legal case that you have before you run out and file a lawsuit over this particular area. So, like I mentioned, pets are what we call chattel. Chattel is nothing but property. Books are chattel, spoons are chattel, and our pets are chattel. There are disputes over chattel all the time, which means that the way that we handle disputes over chattel is pretty much been settled for years and years and years, and it's typically very much the same. If someone steals something of yours or ruins something of yours, unless it's money, it can be very difficult to get back. Courts are not going to go around sending the sheriff to grab a bunch of spoons once it determines that they're wrongfully taken or legally belong to someone else. The way the courts see it is that when property is involved, you can just go out and get a new one. So rather than force a party to hand over property or to repair property, the courts would rather just award you the fair market of the property so you can go out and get another one. You can get a replacement instead of ordering the person to repair it, to return it to you. That said, there is a way to get someone to perform under the terms of a broken contract. It's called specific performance. That means that you're asking the court to force someone to do what they say they were going to do under an enforceable contract. Now, courts are reluctant to physically restrain someone or to force someone to do work when they refuse to do so. But if a litigant is able to show that money damages for a replacement will not be adequate compensation, then the court has a power to force a party to do something more than just pay money. And that's called specific performance of a contract. There's an obvious difference between dogs and people when it comes to children wrongfully held, even though emotional connection to a pet may be quite similar. There's an obvious difference between dogs and people when it comes to children wrongfully withheld, even though the emotional connection to a pet is really quite similar to a child in a lot of ways. The reasons for the different treatments are numerous, but generally, parenting your child is a constitutional right under the United States Constitution. A court can't take away your ability to parent without a judicial finding that you're an unfit parent. There's a huge amount more to that, but that's the gist, and the discussion is well beyond the scope of this video. So, specific performance. When you're asking the court to force someone to do something, it doesn't make a whole lot of sense to wait until the end of the lawsuit in order to have them to be forced to perform under that contract. I mean, lawsuits can take 3 years, 4 years, even longer if it's appealed. If you're going to wait that long, you may as well just ask for money damages. You're asking for specific performance because money damages won't work in your case. So the courts have this procedure that doesn't require you to wait for relief, to get what you're asking for right away when the case is first filed. That's something that we call a preliminary injunction, or a TRO. The standard for a preliminary injunction, which is relief before you present the entire case to a jury or to a judge, subject to the other side's input, is very high. So the standard for a preliminary injunction is very, very, very high. You have to show the court, and the court has to believe, that in all likelihood you're going to win that lawsuit anyway. Second, you have to show irreparable harm is going to result if relief isn't granted immediately. The person isn't, or the party is not, that the party is not forced to take immediate action to remedy whatever the situation is. Third, there's an element that's sort of a balancing test to see if the court, by doing what you're asking it to do now, will cause more damage than it's seeking to avoid. In this new law-changing case, we're dealing with an oral agreement between a boyfriend and a girlfriend. While they were living together, the two decided to purchase a Pomeranian. When the two purchased it, they split the cost of the dog. They both paid the exact same amount. And while they were living together, the two decided, they entered into this oral agreement that if they were ever to split up, that they would share the dog with each other. Well, they broke up after about 3 years, and true to their word, they started sharing their dog, Teddy Bear. Teddy Bear is the dog's name, him or her, I'm not sure. The two continued the sharing agreement until the ex-girlfriend moved into a new apartment, and they both agreed for Teddy Bear to spend a little extra time with the ex so that the dog could acclimate to the new environment. Well, after a few months, the ex-girlfriend decided that she wasn't giving Teddy Bear back, and this lawsuit was filed. So, Judge Fryson in the Middlesex Superior Court decided that, as a preliminary matter, the two had a binding dog sharing agreement. She ordered that custody of the dogs be split between the parties, 2 weeks per party on a rolling basis. She found that the parties co-owned the dog and that the agreement for its use was subject to a binding oral contract. Now, there are certain issues with oral contracts that are beyond the scope of this video as well. They were raised on appeal, but it's fair to say that people who buy something together own it together in what's called tenants in common, and may come up with agreements regarding the use of that thing. That's not particularly uncommon. Corporations often enter into asset sharing agreements with each other over commercial property. You can lease a car when there isn't, a sharing of ownership, but a sharing of possession. We see all sorts of examples of this in everyday life. It's not an unusual thing. Though, until now, there really hasn't been a whole bunch of law dealing with this in the context of pet ownership. But that's what this video is all about. People, mainly divorcees, have tried to get the courts to award some type of custody agreement for pets for a long, long time. The courts have routinely refused to do so, and they've refused to create custody orders over pets. In the case of divorce, the court is just going to do what it does with other property. It's going to award the dog or the pet to one party or the other once they split up. While this is incredibly insensitive to people that may have as much of an emotional attachment to a dog or a cat as they do with a child, the courts have been keenly aware that issues with children are hard enough, and they weren't going to open the door to pet custody orders. Fair enough. That said, over the years, courts have started to recognize this emotional bond between owner and a pet. In cases where the defendant caused injury to a pet, courts have allowed recovery for reasonable vet bills, and the court have said that reasonableness could be based on the owner's emotional attachment to the animal. That's the first time where the courts have really recognized this emotional element of pet ownership in the courts.
Here, there's going to be ongoing supervision. The parties would be sharing the physical possession of Teddy Bear. How is that not going to drag the Superior Court into the same kinds of disputes that the probate court has jurisdiction of because the legislature said so? Here we don't have anything saying the Superior Court can do this.
Well, probate courts specifically won't entertain sharing agreements of dogs because they don't want to be overrun with them.
Right. But my point is they do this in the case of children for very important reasons, pursuant to statutory authority.
Your Honor, I would ask...
Because the legislature wants probate courts to spend their time and the taxpayer resources on adjudicating those disputes in the best interest of the child. We don't have anything like that at the Superior Court level for dogs or cats or other pets.
In this case, in agreeing with the trial court, the appeals court stated that the court is allowed to force performance of a contract where monetary damages are not enough. And as we've said, the appeals court agreed that this existed in this case. So the trial court was allowed to order specific performance of an agreement that the parties had already started to follow but was interrupted, since it was what appeared to be a binding agreement already even partially executed by the parties, and it was a situation where giving the plaintiff money to buy another dog just wouldn't make up for the breaking of the contract. In a situation where holding off until the end of the lawsuit would cause the plaintiff damage that he would never be able to get back, the appeals court said that the trial court was allowed to make this custody order regarding the dog, Teddy Bear. And I can't say for certain, but I'm pretty sure this is the first parenting plan that has ever been ordered in a Massachusetts court. Now, this is where the caution comes into play. First, there are 3 levels of courts in Massachusetts. There's the appeals court, then there's an even higher court, the Supreme Judicial Court, which takes cases of extreme importance or cases that are repetitious, that will be seen again. The case that we're discussing today came from the appeals court. The losing party, here the defendant, may ask the Supreme Judicial Court to review the case, and if the court takes that case, it may have an entirely different analysis and conclusion, which will reverse this entire thing. So this isn't over yet. Also, the appeals court wasn't stupid. Granting what was essentially a parenting plan for a dog was what they saw as blasting open a door to countless lawsuits over the custody of domesticated animals. So before running to court over the custody of a pet, be sure to talk to a lawyer about the facts of the case. The appeals court did place some pretty significant guardrails that must be met before it would enforce one of these pet sharing agreements. Just because you may have an agreement doesn't mean that a court will jump in and enforce it. This was a unique case, and I know Judge Friesen, the trial judge who made the parenting plan, very well. She's a wonderful person and a great judge. Not sure if you'd have the same experience in front of a different judge or a different court. So that's our new dog custody case that we have in Massachusetts. Who knows if we'll see more dog custody cases or dog parenting plans or pet parenting plans between parties who split up in Massachusetts or not. But this is the first time that I've seen such an animal, no pun intended. Thanks so much for listening and watching. I hope you're able to learn something. Before you go, please click on a thumb button, whichever one works for you. And if you'd like more practical legal content, I anticipate posting on a pretty regular basis some interesting law and new cases that come down. So subscribe to the channel if you would like. I'd love to know in the comments if you've ever considered to enter into one of these pet sharing agreements with someone. I'm not sure how frequently I'll post videos, so if you click on the bell icon, I'm pretty sure YouTube will tell you when I post a new video. So thanks again, and bye for now.